show you the page. Yes, it's a make a mistake here. RK held individually, I'll show my lord where 45.6%.
In R20.
That you will find in the other appeal. But for the time being, I'll just set out that fact. RK had 45.6% in R21. My lord, much was made about the litigation expense.
Not reflected here.
No, I'll show you lordship where.
There is some downstream holding.
Yes.
You mention it.
Yeah, and that's my mistake. I don't know.
There's no downstream mentioned here. See, what we are finding over here in this chart is that none of these entities are downstream held. There is no downstream holding.
No, but it's the same five groups are holding it individually. My lord is right. I'm with my lord. But RK was the holder of
Normally, what happens is AP Solvex will
holds
hold
XX.
RK will hold it.
Here the difference is members of the individually took it, except I need to correct one part of this, which I will give my lord. Please show me the document that says it, including this. 45.6% of AP refinery was held by RK. My lord, just make a note of it now. I will bear it out.
45.6%.
So Duri group will not be exactly, the individuals will not be 57.14. That I'll give my lord the figures. My lord, I'll explain where this will be of some relevance later. AP refinery, which is subject matter to the second case, RK shareholding was completely watered down. That is what RK's litigation expenses is about getting their shareholding back in AP refinery. I'll show my lord that later. Because much was made about litigation expenses, I'll slow. RK's litigation expenses was to get their shares, because what they did, and that's been set aside also, they whittled down RK's shareholding completely without notice in our directors' meeting. And that became another litigation, which is the second matter, which RK was contesting, and that's RK's, which is why the legal expenses. Nothing to do with these two fighting. Now, can I come back to this note and everything will become clear? My lord is right. I take what your lordship said. Other than AP refineries, the rest, as your lordship says, is not downstream holdings, but group holdings. Now, what becomes important is this one. In 1998, please see number 2 in my list of dates. Number 2.
Page 2.
Number 2, point number.
Okay, point.
AP Organics was incorporated by AP Group. Now, R1 company, that is RK, which was then lying as a SIC unit, was jointly acquired by the AP Group from the Auroras to complement and supplement the business of the R15 parent company. I keep calling it parent company. Your lordship will see it was, let me say, pyramid company. It was the main one. R1 company had a solvent extraction plant at Dhuri, which was to be used by the AP Group for extraction of crude bran oil and supplied to parent company for refining and sale. At the instance of A1, his brothers A2 and R20 were inducted into the business of the AP Group. After takeover, what happens? This is the 1998 what happened. At the same time, the Auroras resigned from the board. A2, R2 and R20 are appointed as directors, as representatives of the AP Group. This was at a stage when there were no internal or subgroups within the AP Group. They were all together. So it didn't matter, it was one or the other. The Auroras agreed to sell their 20,850 shares to the AP Group. They transferred 2,600 shares to A2. Article 15, just to pause here for a second, A2 was not a shareholder on that date. It was sold by Auroras, who were the promoters, to A2. A2 was not a shareholder for Article 15 to apply. Article 15, if that was so, he was not a shareholder. 6,100 shares were sold to A1, who was not a shareholder. And 3,050 shares to R7. These were the shares which were registered. And registration of 9,040 remained pending, though consideration was paid in full. Here, the concurrent finding of fact is consideration was paid. That is a finding of fact your lordships would not look at under the NCLT Act, my lords, the Companies Act. It's only a question of law. Anyway, concurrent finding of fact, their own affidavit. Person who sold it says, I received the money. So that, my lord, is not the issue. But the fact is, and let me state it at the outset, transfers were not done. But at the same time, different members of our group, they bought shares. I bought some shares. The others bought some shares. And 9,020 shares which were to be bought were paid for, but were not transferred. Rest were transferred. The solvent extraction plant and machinery was kept on lease with who? With R15.
Just tell us, the property in the goods would get transferred the moment consideration and paid and the
In sale of
shares
goods
are
act.
handed over, or it would transfer only when the registration takes place.
I'll answer, my lord, straight away because I don't believe in running away from law. Under the Companies Act,
It would only under 108.
absolutely. I'll be the first to say that. No doubt. But we're dealing with the 391, 392.
Yes.
My lord, we look at the overall
Overall
equities
acceptable.
and all that. So I'll be the first to say Mananal Kaitan onwards and 108. Thereafter, my lords, other judgments, even Howrah Trading, refers specifically, you might be a custody trustee of the shares. He may be holding it as your trustee. And you may have inter se rights. But where the company, it's only that. Sale of goods act, transfer
That's
takes
correct.
place on delivery.
That's-
Not so with shares.
Not-
Not so.
Mr. Sundaram, as far as these transfer of 9,040 shares are concerned, there is a finding against you by the NCLT,
I'm answering that.
which has not been challenged.
Yeah.
Therefore, for you to canvass today before us that this is a part of a 98 transaction, and therefore this should have been allowed because this meant transfer from the erstwhile promoters to the new promoters, to which this faction also was a part, may not be correct because you cannot question that finding today. Like you were saying, in 136 or in this appellate jurisdiction, you will not interfere with the finding. We will not go behind the finding of the NCLT.
Please don't, my lord.
Those 9,040 shares were wrongly issued, illegally issued.
I'm sorry, my lord. I'm with your lordship on what your lordship has heard.
Yes.
You haven't seen the other parts of the order.
No, we are right.
No, I will say this.
Yes.
NCLAT's legal conclusion
Hmm.
that whether the share transfer took place to me or did not take place to me, not on the fact, on their legal conclusion, they had various findings. NCLAT seized with that same legal conclusion, came to the conclusion that that legal conclusion was wrong. I don't need to take my lords its carrying poles to Newcastle. I can always sustain or demand an order based on my pleadings in the appellate court, provided the pleadings are there and a conclusion can be sustained. I'll show my lord that, please. I've heard my lord on this. I will definitely answer it. Straight on, I will answer your lordship's question. But let me just finish it. I will be showing my lord that the findings were all there to show that I had paid the money. But as was pointed out by my Lord Justice Mishra, there is no doubt that under the Companies Act, the share transfer is not completed. There's no doubt. I'm not even going to take time trying to argue to the otherwise thing. But now let's see the legal consequence of all this in a 421. I mean in a 397 at the relevant time. That's all I'm asking my lords to do. Please now see what happens. Much was said. How did that outsider buy it? I want to shed that first. We were all outsiders. None of us was an insider.
So did you enter into some agreement
I'm
with
sure
the
you-
erstwhile promoter saying that we are going to take over the entire 100%
Well,
shareholding of this company?
Yes.
It will be done in this manner, and this 9,040 shares will come to R2 to R6.
My lord, for that we have the word of the promoters. And let me make a statement even today that after these judgments, because the NCLT said have a fresh meeting and then vote and then decide who should be the directors. Because of this litigation and findings, and I was worried about what will happen, the promoters who sold me the shares attended the meeting. Those very promoters, Aroras, attended the meeting, which has not been pointed out to my lord, and voted out X and voted me in as the directors. What my learned friend has not come out with is the fact that subsequent to NCLT order, which was appealed and there was no stay. The NCLT said have a fresh meeting. Whether NCLT said it or did not say it, shareholders can always have a meeting. There was a meeting called. A stay was sought of the meeting before NCLT, which was not granted. Meeting went on. I did not vote the 9,020 shares. Auroras came personally, attended personally, and voted the shares. And the Auroras voted me, the directors, 369, etc., as directors, voted out R20, and I'll show my order. And that is subject matter of yet another CP which has been filed by them, which is pending before NCLT. A fresh CP, naturally, so it's a fresh cause of action. The fact of the matter is there were two.
That is what we call evergreening of litigation.
The point is, in fact, I'd like an end to this because please see my position today. Even what fell from my Lord Justice Manmohan, what happens then? Then pro rata between two. Let's take the worst case. Should have been given pro rata for both of us. If it's pro rata, I'm still 52%. And I heard my learned friend say, direct them to sell out. I will buy it for whatever price. I'll take over the company. Whichever way, I was the majority. And in fact, I'm very happy if you say, let the promoters continue. The promoters will come, they'll vote all their shares for me.
No, the question will then be, see, that's begging the question. The fundamental question which he is raising is that in view of the articles, there is no question of anyone agreeing to sell to an outsider, even if by majority vote. You may be 75% of the voting class.
I'm not there.
So
I'm with my Lord there.
Articles, if they operate as a bar, they operate as a bar.
My Lord, I'm with.
He also agrees.
Yeah, and he is also barred against him in 1998.
But the problem is,
My Lord, let me just answer, my Lord. My Lord, we are in a 391 jurisdiction, which is slightly different.
you are saying the shareholders will contract out of the contract.
No. I'm saying in 1998, when our whole happy group in those days
Yes.
decided to buy, none of us was a shareholder.
Yes, you're right.
So the promoters who sold to us.
That time the existing shareholders agreed, but now when it comes to your sale,
No, my
of R2 to R6, he's an existing shareholder.
Therefore, my lord, in an equity jurisdiction, what is found favor with the courts below was at that same time, part of the same transaction, even you pay the consideration, but your transfer was not done. Legally, my lord is absolutely right. Theirs was fortunately done. So they became shareholders. Mine also was done for certain shares. I became a shareholder. What was unfortunately not done, I did not become a shareholder. Legally speaking, my lord is right, which is why in Needle Industries it's so beautifully put. Every illegal act is not oppressive. Every legal act need not be non-oppressive, and we are dealing with oppressive mismanagement. Now, my lords, at the very same time, this whole transaction was to take place. I will state this here and now. While the whole transaction was to take place, X number of shares sold to A, so much to B, so much to C. In that whole tranche, 9,020 got stuck up. And though consideration received were not transferred. But what was done in 2010 was giving effect to what was decided in 1998. Nothing new. And they did not object for 3 years after that. 3 months before limitation, they've objected. Why? Because in AP refineries, my lords, they diluted RK, and AP refineries, we filed a petition. So when we filed the petition, they immediately filed this petition 3 years after the fact. Because they also knew what the situation was. The problems actually arose out of AP refinery. That is where I came down in AP refinery 52% to 9%. You'll be seeing it in the other case. When that happened, RK has filed for 391, 392 in AP refinery, subject matter of the next case before your lordships. After the filing of that case, this case came to be filed, this CP. The reason, my lords, is to the very simple deal. None of us, we were a family, I'm not family, friends, whatever group at these companies. RK was a sick company. We say, let's buy over RK. We all go there quite happily. RK, my lord, say, yes, we will sell you. They enter they say, we'll sell you. Okay, and we tell him, you sell him so many shares, me so many shares, him so many shares, etc. Consideration paid. The person who's meant to transfer admits by affidavit receipt of consideration. So consideration paid. Transfer actually does not happen for 9,020. So today the argument taken is 9,020 shares transfer did not take place. Therefore, you are not entitled to that 9,020 shares. Whereas what did happen was those 9,020 shares, even in 2010, the promoters gave a fresh transfer deed, which answers my lord's question, what is the pendant, how long can a transfer deed? So they gave a fresh transfer deed in 2010, which again shows that they received consideration. Otherwise, they're not going to give a fresh transfer. And my lords, that transfer deed is what was given for registration and what came to be registered, which they're questioning now. The point I'm trying to say is, if in equity your lordships find that the transfer was actually done, not de jure, but the intent of transfer to all of us was in 1998, then Article 15 does not hit anybody. Article 15 can't be an article aimed only for my heart. And nobody else is affected by Article 15. The happenstance that within the Aurora group, suddenly a dispute arose, so they couldn't honor their commitment for the 9,020 shares. Then that dispute came to an end, and they honored their commitment for this 9,020 by giving me a fresh transfer deed in 2010. That, in short, are the facts of the matter. We made a mountain, my lords, out of a molehill. That's why I said the law, my lords, is very clear. Your lordship put the question under the Companies Act. Is it a valid transfer without the transfer deed? My answer, no. But you're dealing with a 391. What is inequitable in this? They are trying to rely on Article 15. Then your lordship first question to them, if Article 19, please say Article 15. Under 15 and 16, then notice must be given to everybody.
See, Article 15 cannot be read in isolation.
Yes.
It has to be read with 16.
Yes.
Now, when the Aurora's group were in control of the company and they were willing to sell, then 16 did not apply.
Yes.
Because 15 would only apply when somebody is prepared to buy.
Yes.
So if the Auroras, who are the holders of the entire share capital, they are willing to transfer, then 16 is not coming into existence because they are not willing.
Absolutely.
So therefore,
my lord is
your argument,
yes.
Therefore, your argument that since they have themselves breached 15 to get into the company, that cannot.
No. I'm not. Sorry, my lord. That was not my argument. I'm sorry. I put it wrong. I'm not on the fact they breached 15.
No.
I'm saying
they acquired in breach.
The scheme was no, my lord. It's not even in breach.
Yes.
The scheme was that all of us are buying from the promoters.
That's right.
Like I said, consideration passed, but a transfer deed for one particular tranche of the shares to be transferred did not happen. That happened in 2010. Now I am saying
they also acquired in 98 according to
90, all of us.
These were the additional shares which you had.
Yes. All of us acquired because it was not our company. We had no shares in the company. RK was a sick company owned by the Auroras and their friends and their group. So we approached the Auroras to sell RK so that we would buy it and before BIFR.
I asked him whether there was some agreement, interstate between you, how you would purchase the Aurora's group. Otherwise, there would be some interstate agreement that so many shares would go to A, so many would go to B, so many would go to C. Then you can tell us that C, the tranche which was to be sold to C did not take place in 98 but took place in 2000.
Can I just show my lord?
How do we get that?
Yes, I'm just going on. Please permit me to go on. Now, that's the second question I will have to answer to my lord. First was the first one you put to me. Now, my lords, kindly see. After the takeover, 3 events take place. Auroras resigned from the board. A2, R2, and R20 are appointed as directors. Why, my lords? We did not see R20 as so-and-so's son, etc. We saw it as we're all friends. This boy will go into this, I will go into this, you go into this. This was at a stage where there were no internal subgroups. Aurora has agreed to sell that 20,850 shares to the AP group transfer of 2,600 shares to A2, 6,100 shares to A1, 3,050 shares to R7 were registered, and registration of 9,040 shares remained pending, though consideration was paid in full. This, Your Lordship says, where do I get it? That is found in the affidavit of the Auroras filed before court. I'll take my lord. Your Lordship is saying, where do I get that? I get it from an affidavit filed by the Auroras. Now, my lords, the only thing I must say fortunate in all this litigation is they have been very straightforward. And not because, my lord, I must say, because after this NCLT order, because they've gone to NCLAT, there was a genuine fear that in case the matter loses there, then what happens about the removal of directors? They will say anything subject to NCLAT. So notice was asked when the Auroras were asked to come and vote themselves. And fortunately, they agreed and they did so. Now, my lords, the solvent extraction plant and machinery of R1 was kept on lease with the R15. I called it the parent company, but will I change the name to Pyramid Company, where we all had an interest. So the lessee is a company in which we all have an interest. The same people who have an interest here have an interest in the lessee. My lords, on that day, appellants held 25.6% of the shares. Respondents held 8.97% of the shares, and erstwhile promoters continued holding 65% of the shares. At the time of takeover, appellants held only 8,760 shares of R1 company, that is 25.76%, and not 53% as claimed in these pages. Why, my lord? Because the promoters' shares are still with the promoters, including that 9,040 shares. Sorry. Sorry. Now, my lords, AP Refinery AP Refinery was
Yes.
was incorporated by us by the AP Group to supplement the business of R15 parent company. Again, my lord, please say wherever it's parent, let's call it Pyramid. At the time of incorporation, respondent held majority shares, 57.14%. A2 and R2 were inducted in the board of R21 as representatives of AP Group. Please notice, my lord, even on that date, A20 and R20, A2 and R20 were against me today. Although our group had the majority shares, we made them the directors. Even at that stage, there were no subgroups in the AP Group. Now, 2006 to 2010, this is the admitted position, as your lordships will find from the balance sheets, and they have also been fair enough not to question that. R1 company, appellant held 18,000 shares, 34.7%. Respondents held 19,050 shares, which is 36.6%. The erstwhile promoters continued holding 14,000 shares, which was 28.7%. This includes, my lords, the 9,040 shares. This 14,000 shares includes that 9,040 shares. The list of shareholders annexed to the annual return of R1 company confirms appellant shareholding and so and so. From 1998 to 2004, plant of R1 company remained on lease with R15 parent company, and 2007-10 on lease with R21 company. In 2010, disputes arose between the AP Group because of involvement of the sons of the appellants. In the business. Contrary to the understanding of the AP Group that R21 would continue to supplement the business of R15 parent group, under the influence of sons, appellants sought to gain complete control of R21, which is AP Refinery, subject matter of the second case. My lords, please note AP Refineries majority was held by the respondents. There were discussions between the members of AP Group. It was decided both R1 and R2 would continue to be part of the AP Group and supplement the business of R15 parent company. On 1/6/2010, admittedly, the lease of the solvent extraction plant was again transferred to R15 so that R1 continues to supplement the business of R15. Now, my lords, the alleged illegal acts start at page 7. R6 and R7 were appointed as additional directors on the board of R1, comprising of R2, A2, R2, and R20. Appellants denied participation in a board meeting, appointing R6 and R7 as additional directors. Since the members of AP Group lived in close vicinity, the practice of sending notices in writing for board meetings was dispensed with a resolution dated 10/6/2003. This has been found favor with, my lords, by the courts below. In order dated 11/3/2015, erstwhile Company Law Board has recorded as under R1 is admittedly a closely held company. Interestingly, it is admitted by both the parties that there was never any requirement to send formal notices of board meetings to the directors of parties who were working on mutual trust and live, my lord, together in that same area, that AP enclave, etc. AP enclave, yeah. The fact that there was a board meeting on 14/8/20 in the presence of A2 and R20 can be substantiated by the fact that the same board meeting, A2 and R20, madam, this is the board meeting they claim they did not attend. But the very same board meeting, they approved and signed the balance sheet of the company for the financial year 2009-10. Very same board meeting of 14/8, which has been found they did not have notice, etc. In that very same notice, the annual report was my lords, approved, and they have signed to it. Nowhere the appointment of R6.
No, they have signed those board minutes of 14th August 2010.
No, not board meetings. I'm saying the balance sheet, which was passed on that date.
The balance sheet is something different. The only question is, if you are pointing out that they are members of the same family living together, then normally you would invite them to the board meeting and they would sign the board minutes.
Yes.
And
No, board minutes is only signed by chairman, never by others.
members
No.
would.
No, only chairman.
So, no, but is their attendance would be shown?
Yes.
Attendance is not shown. I am asking this. Is their attendance shown?
On 14th August, yes.
Yes, we are asking.
Yes.
Attendance is shown.
Yes.
Their group attendance.
Yes.
I'll show us that.
I'll show you.
That is very important.
I'll show that.
Or in the next meeting where the confirmation is taking place.
Or more important,
See, if there is a confirmation of the next meeting or the previous board minutes, then show us they attended either of the two.
and more important, if you have approved the balance sheet on that day, I'll explain why the importance.
You don't know what is transpired in board.
But then the balance sheet, when they sign, they know it was approved in the meeting.
Right?
Because the balance sheet will say approved in the meeting, the board has approved it, it's come for the signing.
Okay, but they don't know what is transpired in the board.
That not important, my lord. 2010. The dates are what is important. Because they don't come up in 2013. That's what I want to show.
Because they probably did not know what has transpired in 2010 unless until it went show.
Yes.
That they know what has transpired in 2010. If they have updated the board minutes of 2010, you show us that. Or in the next meeting where the previous board minutes would have been confirmed, you show us either one of the two. Then that presumption will arise which you are saying.
Page 17.
Page 17
Of CC 1. CC1.
What is CC1?
Convenience compilation.
The attendance register they have produced is from 5th October.
The balance.
The attendance register they produced was from 5th October. And that's on record. I'll show that now. 5th October, not from August.
Bro,
What is the page number?
say whatever you wanted. Page 17.
Yes.
Ravinandan Goyal, number 2, has attended.
So you are showing the presence is shown.
Yes,
Ravinandan.
Ravinandan Goyal. And then kindly see page 21. 21. Yeah, 1 second.
21. Yeah.
21. Kindly see item number 6.
Yes.
Chairman placed before the board balance sheet as on March 31st, 2010, along with profit and loss account. On that date, together with the schedules, notes of account, and directors discussed the matter and passed the following resolution. And your lordship will kindly see page 22, the last paragraph. Resolved further that Shri Shiv Goyal and Shri Ravi Nandan Goyal, who's A2,
Yes.
be and are hereby authorized to sign balance sheet and profit and loss of account on behalf of the company in accordance with section 215 of the Companies Act. At this juncture, resolved to adjourn the meeting for 15 minutes, enable auditors to submit their report, to resume with consideration, was adjourned, etc. Auditors report. Now, please come to page 45. 45.
See the date first.
Well, it's page 45 is the balance sheet. Yeah, just please, all of you relax. Page 45. Kindly see the date. 14/8, very same date. And please see Ravi Nandan Goyal's signature. Well, I'm only on this. Please see it in the overall spectrum. We are talking about a 391, 392. We are not talking, my lord, about a strict plaint pleading and that kind of thing. It's an equitable jurisdiction. Please see the overall background. And my lords, it is admitted by them also that we were never in the habit of giving notices. That's also admitted by them. Whether that's the right thing to do, wrong thing to do is not the issue. But the point is, it's not that they are totally in the dark about all this.
No, if they have attended the meeting, then they have a problem.
And my lords, not only that, for 3 years they don't come after that. When do they come? After I file a 391 for AP refinery. Because AP refinery, my lord, basically I'll explain what happened, my lord. They wanted to take over AP refineries. They were willing to give up RK and wanted AP refinery.
Even everywhere else,
That's a proportionate. Malad, there were 5 people, Malad, who had got together. What happens actually, Malad, is because even
Which are the 5 factions?
even the suggestion was made by them, give us AP refineries, keep everything else. The point is, that's where the whole problem arose. Because they brought down AP refinery from, there are no 5 factions, it's only them on one side.
No. But there must be 5 families.
yeah.
There are 5 families or 5 groups? What are they?
5 friends. 5 friends.
Who are those 5 friends?
At page 1.
No, in this that you have given us page 1.
Page 1.
That color.
No. Page 1 of the
In the convenience
convenience company.
Okay. Yes.
Page 1 will show the 5.
Yes, sure.
Arun Kumar Goyal is him.
Yes. Yes.
Vijay Kumar Goyal is R2. Purushottam Das Garg is R7. Pavan Kumar is R6. A.R. Sharma, who's the inventor of the patent, is R3. He was one of the brains trust. Now, please see what is today. What are your lordship faced with? Is Mr. Arun Kumar Goyal says, no, I got to take over all this. All the others are together. Mr. Arun Kumar Goyal is building this case out of, yes, legally, 108, Mandalal Khaitan, it's a fact. But you can't twist law to your favor or use law to your favor to twist equity in an equitable jurisdiction.
No. Mr. Ravi Nandan Goyal is who?
That's him.
Part of this A2.
Part of his Arun Kumar Goyal, A1.
Part of A1 group.
A1 group. He's A2. Is it? He's
Yes.
A2.
But he belongs to Arun Kumar group.
Yes.
Yeah, these are the 3 people who are part of it.
Now, at page 3. Page 3, you will have Arun Goyal and Ravi Nandan Goyal are the same group.
And then all the others.
And all the others, my lords, are the respondents. And actually, this is the case your lordships are being asked to agree to, which is what? That these shares registration was not done, 108. Therefore, I have got into this happy position, I can take over this company. But 391 is only to prevent that kind of action. 391 is not to further such action. My lord, they filed a 391 and they want an inequitable relief. And my lord, I can only keep thinking of the beautiful words in legal industries. Every illegal act is not oppressive and every legal act is not non-oppressive. And the jurisdiction is a 391 jurisdiction.
For other illegal acts, you have to go to the civil court.
Absolutely. But not come to a court of equity under 391 and say, I'm being oppressed.
But ultimately, Mr. Sundaram, some division will have to take place between the five.
Well, your lordships have tried so much.
No, forget it. Ultimately, there will have to be some. See, these are quasi partnerships. You will have to give him a share in management. It cannot be that he's without management.
No, he does have certain areas.
How will he have certain?
Well, for example,
you will have to give him some area of management.
I'll explain where all these problems occurred, Malas. There was no problem originally at the first generation level, as in all these families. First generation level, there's never a problem. Problems arise from the next generations, which becomes then the grain for the lawyers. It starts from the next generation. Mother, what happens is that a working out can be done by which companies or shareholding in companies can be divided in a way that is equitable. It could have been done by these five.
No.
What happened, I'll explain to your lordships, was suddenly in the year 2010 or 12, just before these petitions came to be filed, AP Refinery, which was 52% of the respondent group, and RK holding the balance. And they had hardly 8 to 10%. 52% came down to 9%. 56% came down to 9%. They were not issued themselves 14 lakh. They validated 14 lakh odd shares and gave it to themselves. And on what basis, my lord? Please notice this. Their claim was RK transferred them the shares. That RK transferred them the shares of RK in AP Refinery. Manoj, that's why that money which had been raised by RK for the purpose of the boiler, and I'll show you, Lordship, how the initial purpose of the boiler then got spent into trying to get the shares back in AP Refinery, the lawyer's fees. And what happened was AP Solvent thereafter stepped in because it was a pyramid company and said they will pay for it. And who is AP Solvent? Once again, the respondents. The respondents are the majority holders of AP Solvents. So we came through another avatar. Through AP Solvent, we came and gave the money to repair it. That's not a different matter. I'll deal with that matter and I'll show you, Lordship, the unfairness of that subsequently. But these facts are important for your Lordships to see. It's not a matter in abstract.
No. Therefore, you're right. These matters are not in the abstract. Ultimately, we have to find a business-like solution in a 397, 398 jurisdiction. We can't allow five family factions to run this, and every day everyone is having a bitter fight. And every beginning of the litigation, the second CLP petition is still pending. We have to bring it to our quietest. I think, we have to finish it. We can't allow it to linger.
Can I tell my lords a very funny thing which has happened? You will find that when AP Refinery's case comes up.
Yeah.
We succeeded in AP Refinery, where the defendant also in AP Refinery. We were the petitioners in AP Refinery. In our case, they are the petitioners. AP Refinery, like I said, they brought down our shareholding to 9%. Not only did they bring down our shareholding to 9%, they are now competing against AP Solvix.
Ultimately,
so now we have become competitors.
So to become competitors, we have to branch them off. No? See, therefore, what we are thinking is,
yes,
there are five companies involved in this, right? APS, APO, AKC, Ricilla, Chemical Oils.
No, 1 second. Tell me which one
he has given. Only if you have his chart.
Your Lordship remembers.
I see.
You have his chart?
Yes.
Page 1 of his brief background.
Even in the arbitration, we had said you take everything else.
There was no arbitration. My lord, I want to also point out, I'm going to show you, Lordship, the so-called I kept quiet. My learned friend used the word arbitration. I was wondering who the arbitrator was. I'm asking them, where's this arbitration? What did the arbitrate? It wasn't. It was a draft signed by some people saying, why don't we work out a settlement on this
Signed by you. Doesn't matter. I'm saying.
Was it an arbitration, Mr. Mehta?
No. I'm not saying
Please,
that. I'm
thank
not
you.
saying
Thank you for being.
No, I'm not saying.
Manan, I kept quiet throughout. I allowed him to say arbitration award once. He said arbitration award about 10 times.
No, I didn't say that.
Ultimately, we'll have to find and segregate these companies somehow.
Yes.
So that you have a separate sphere and you handle a
Which is
separate
what I
sphere.
The quarter today
Everything. And
is RK Chemicals and AP Refinery.
Yes.
This is the quarter.
Yes.
So far as Solvex, Organics, and Ricala Chemical,
Rice.
Raisala.
those there are no quarter. Quarter is Quay, RK Chemicals, and AP Refinery.
Ultimately says in his, at least in his brief background note, that there are 5 companies which were set up by all of us together. 5 companies. That's what he says. Original promoters founded 5 companies. I don't know. You accept that fact or not?
That's absolutely right.
And
If
they
that is so, then we can segregate and give him one company and so that he handles it on his own.
that's all I'm
But
saying.
they're so interwoven, my lord, because let me explain.
Yes, yes,
They're all interwoven. For example, the R15
yes.
is a lessee of the plant.
So that is APS and AKC.
AKC. Now, refineries, the investment was made by, they supply the material, the rice brand to Solvex. So they're also intertwined. It will have to end with one person going out.
Are they supplying today to APS?
No,
Yes. Therefore, that linkage has been broken many years ago.
not many years, my lord.
2010 at least.
Yes.
13
Yes.
years ago. 13 years ago. Now that one mass must come to an end. 14 years ago. Bring it to an end now. Yes, you are right. This is a part of the overall strategy. That this 9,040 shares want to be transferred to Mr. Respondent 2 to 6, who was also a part of the faction. Then one understands what you are saying. Then everything falls in place. But ultimately, we have to finish this fight which is taking place on a daily basis. Somehow you have to resolve this. You cannot allow this fight to fester.
Why not buy out one or the other?
Either you buy out, one person gives a valuation and the other person pays. That's the normal way in the CLB we used to do. Ultimately, after fighting, after picking up, we would say,
We buy out one.
have an option. That's the only way out. One person gives a valuation.
They
the
say
other
they
person
will
can't
be
bid.
from RK. And you give them AP Refinery. That's what they want.
They want APR, that is one way out. If you don't want to get APR, then for each company have a bid and whosoever
For
gets
the other companies, there's no issue.
Then there is
The problem is these 2 companies.
either way, you have to give it to them.
What do you want? They want to take over. I
understand.
He's the one who was doing the.
Mr. Mehta and I tried. We
You know, forget that. We are not. Ultimately, in a 397, when we are exercising 402 jurisdiction, our power is immense.
Yes.
Your lordship is right.
402, I think the landmark judgment is the Bombay High Court, the Bennett Coleman, if I remember. The 1977 judgment. Right? We used to use it randomly. All the time. 75. So, see, ultimately, we have to find a solution. We have to finish this mutual bickering which is there now. And you cannot live together. That is apparent. Either you have a bid for each company, you bid, and whatever is possible, the highest bidder will walk away with it. Either we have a bid or we segregate and give them one company and you handle the other
And
company.
that was the scheme of 2 documents, 2010 and 20.
Yeah, doesn't
signed by
matter.
all parties. So no, signed by all parties. But again, that is
Ultimately, we have to resolve the matter. No,
correct.
we can't allow it to fester and have a second round of CLB. No point of having a second round of
I
CLB.
appreciate that. There shouldn't be. I mean,
My
other
lord is-
litigation is carried.
My lord is limiting the rounds.
Huh?
You're limiting the rounds.
Ultimately, that's the intent of 397, 398.
Put an
Finish the litigation.
Final
Give it a
settlement.
fighters. The company must not suffer in the process. You know, company is a juristic entity. It's looking after the economical interest.
I'll explain to you where I'm faced, my lord.
No, I
On
understand.
the one hand, I took away AP
The
Refinery.
moment you
On the other side, even RK is trying to apply all this law and throw me out.
the moment
Everywhere he's trying to throw me
No,
out.
the moment you have an arguable case of 9,040 shares, then everything falls in.
That's right.
Then the rights issue will also fall in.
I mean,
Yes.
technically, because what's happened is that
So
some
therefore, but only we have to find a solution. No? There are 5 factions and there are 5 companies. We have to find, give them a company to deal with. Ultimately, it's a quasi partnership. No, everyone has a right to manage.
There's no doubt.
There's no doubt about it. Maybe he has a less shareholding, but still he has a right of management. So you find a solution, otherwise we'll find a solution. And then don't blame us that we have done something whereby the group has become unworkable. Because you are giving it to us how to handle it. That's a problem. You will have to find some solution. If you can't, we'll do it, but then it may be bitter for all of you.
I only wish your lordship
So
would
when
resolve
will
the
it, can we
Tata mystery issue. It would have been sorted out the same.
Whatever it is, whatever we can resolve, we must resolve. No?
That's right.
That's the intent of it.
Correct.
You have done so. See, you have such a wide experience over there. Ultimately, what happens? One family faction takes it over.
Would your lordship, you better come up with a suggestion? Why not let both sides try to come up
I
with a
come up on Tuesday. Otherwise, we make use of this vacation and then do whatever we can.
Well, the matter is,
But I take it your lordships haven't concluded my submission.
No,
No.
You take how much time will you take? You do it now.
I'll take another hour.
be okay?
What is that?
It will be a miscellaneous week, so we can keep it at the end of the board.
Oh, is it? Well, we were not there. Is that miscellaneous?
I told that
Why?
the
I see. I was not aware. Well, we can do it on Tuesday.
Look, there'll be the second appeal also, the AP refinery.
anyway.
Then would your lordship take it immediately after
It's the first.
that will also give them time to
Forget it.
Yes.
Accommodate us. Either we can even keep it on Monday at the end of the
Monday.
And Manoj,
Yes.
the
Monday.
pressure is on.
Because Tuesday I've taken some
Your lordship, keep the pressure on us.
There is no pressure. Pressure is only on us.
We'll have it on 24th.
Monday is as pressurized as possible.
24th.
24th, Tuesday.
Monday.
Sundaram is Tuesday.
Monday.
You want Monday?
yes.
Monday, your lordship said end of board, you take it.
Monday is 23rd.
23rd. Please, my lord, 23rd.
23rd.
24th, I got.
All right.
Monday.
Please, your lordship.
23rd.